The panelists, I'm going to run through their kind of their background right now, and then we will get started. First one that's going to be up, it's out of order on your list. It's Keith Good. I met Keith Good in 2007 when I went to work for the Underground Water District, North Plains Groundwater Conservation District up in the Panhandle. I'd been working in the Edwards for years, and they grabbed me and dragged me up there and gave me a job. And Keith is the attorney for North Plains GCD. He is with Lemon Law Firm out of Perryton, Texas. Over the years, I've gotten to know him as not only as an absolutely excellent attorney, but also as a good friend. Keith's firm, Lemon Law Firm, has been the law firm for North Plains GCD since 1954, which is astounding since we didn't really get created till 55. Lemon did the original setting up our district. With that, Steve Kossib will be next. Steve Kossib and I go all the way back to 1996. I've known Steve a long time. He is working for San Antonio Water Systems and then water rights and water acquisition. Steve also has worked for several different private landowners and property right owners in his past. And Steve and I, he's the first person to ever put me on a stand really and depose me, and he just tore me up. So I think a lot of Steve. The next person will be Mike Keister, and Mike has been around since 2003. He's a hydrogeologist and a project manager for LRE. I believe that several of your districts will have will maybe using Mike. If you're not, you definitely need to look at his services. And the last guy is, and I'm going to mispronounce your name, Greg Wakash. Wukash. Okay, Greg Wakash. Wukash. He's been at San Antonio Water Systems since 1998. That's a long time. And he's been part of manager of external affairs, and he's going to really bring a good education program. With that, we're going to start with Keith. Come on up.
Thank you, Steve. What a privilege it is for me to serve in such a great array of presenters, and I appreciate the opportunity. Today, we're going to address the essentials of Texas Water Code Chapter 36. Now, this presentation could sure take an hour and a half. We've got 20 minutes, so we're going to cover it at about pretty high altitude. But we'll try to get the essentials and go on from there. So let's and all of you, we have a handout that hopefully you picked up. There are two things on that hand. First of all, it's more detailed than our slide presentation because of the time constraints. Thanks, Steve. And the on the back page is a director's verification for fees. It's a draft, and it can be modified. I've given it to Steve, and he's already modified it. But anyway, it's just a suggestion on how for a director to file a verified report for collection of fees from the district, as well as his collection of expenses. The essentials. Chapter 36. In the beginning, in 1995, the Texas legislature consolidated groundwater conservation district law into Chapter 36 of the Texas Water Code. Chapter 36 provides for the creation of districts, the means of governance, their powers and duties, and oversight by the state auditor and TSEC. I'm going to cover three of those. I'm going to briefly hit governance because Steve Kossib that's his topic for the day. 36.052 provides that other laws are not applicable, and that leads you to believe that 36 is the only law that impacts the governance and operation of a groundwater conservation district in Texas. That's not true. One of the key laws that does impact the district is the district's enabling legislation. It trumps Chapter 36. Now, you'll notice that there's a Twitter bird and the word Trump on this slide, and it's not intended as a political statement. Examples: 36105 grants eminent domain authority to a district, and a district's enabling legislation may deny it such authority. Section 36.201 sets the maximum tax rate, ad valorem tax rate at 50 cents per $100 valuation. A district's enabling legislation may set a lower rate. Example: North Plains Groundwater Conservation District, which Steve and I work for, sets a cap in its enabling legislation of its ad valorem tax rate at 5 cents per $100 valuation. 36.101 sets forth public notice requirements for hearings, and again, a district's enabling legislation may have additional public notice provisions. There are many statutory engines out there that impact the governance and operation of districts, groundwater districts in Texas. And I'm going to go over these very quickly. And this list is not exclusive, but it indicates the magnitude of impacting statutes. Statutes, governing statutes beyond Chapter 36. Texas Government Code, several chapters. Texas Local Government Code, several chapters. Texas Tax Code, several chapters. Texas Election Code, 3 volumes. Now that we're to our topic of the day, the essentials of Chapter 36. Groundwater districts under this chapter are created in the state of Texas for the conservation, preservation, protection, recharging, and the prevention of waste of groundwater. The Texas legislature has gone on to make this statement, and I'm sure it's a familiar statement to all of you. Districts created under this chapter are this state's preferred method of groundwater management. Creation of a district may be created by action of the Texas legislature, as we just discussed, the enabling legislation, and landowner petition to the Texas Commission on Environmental Quality. I'll be referring to it throughout this as TSEC. It's quicker to say. Speaking of TSEC, under its priority groundwater management area powers, it can also create a district. Ownership of groundwater. 36 clearly recognizes that a landowner, as our Supreme Court owns the groundwater beneath his land. Does not grant a district authority to divest or deprive an owner of his groundwater rights. However, it does not affect the authority of a district to regulate spacing and production limits. Quickly, GCD governance, deferring to Steve. Board of directors, sets forth board of directors of 5 to 11 board members. And again, enabling legislation may have a difference there. Now we're going to defer to Steve. Powers and duties. A district may, and I argued with you that it's obligated to make and enforce rules to conserve and protect the groundwater within its confines. It's got to develop rules that address the issues that it's faced with in its particular district, and then enforce those rules. When setting rules, a district must consider all groundwater uses and needs, develop rules that are fair and impartial, consider groundwater ownership rights under Section 36.002. We just talked about that. Consider the public's interest in conserving groundwater, and consider the district's goals and its management plan. And we'll talk a little bit more about its management plan here shortly. Rule enforcement. District may enforce its rules by injunction or by assessing reasonable civil penalties not to exceed $10,000 per violation, with each day constituting a separate violation. If the district prevails, the court shall grant attorney's fees and cost of the suit. That's in enforcing its rules. Examples of enforcement actions: illegal wells, metering and reporting requirements, failure to do so, overpumping, exceeding pumping limits, waste, and failure to pay assessed fees. I have found in my representation that one of the most effective ways of a very effective way of enforcing rules is a show cause order issued by the board of directors. That show cause order is issued to an alleged violator and presents him a due process opportunity to come before the board in a formal hearing and present his side of his case as to why he should not be assessed a civil penalty or enjoined from some action he is taking. Another enforcement tactic that we found effective is a deferred settlement agreement. The concept is to bring that violator into compliance and not penalize. The way that works is the agreement, the deferred settlement agreement, provides for, first of all, the correction of the default or the violation. Secondly, any civil penalty assessed is a percentage of that is paid up front. The balance is deferred, and so long as there were no other violations within a 3-year period. And that again has been an effective tool. 36 provides the rights of district representatives to enter land. Everybody recognize Inspector Cluso? Anyway, there are some caveats on entering land. First of all, that representatives should be prepared to display proper credentials to the owner of the land or the operator of the land. Secondly, if at all possible, the landowner or operator should be notified in advance that this district representative is going to be present on the land. Third, if that representative is approached and asked to leave, our recommendation is that person leave and not try to argue or have a confrontation with the owner, for example. And then if it's necessary for that representative or the district to be on the land, seek court authority to do so. But don't argue this power under this provision of 36. Permits. A district shall require permits, except for exempt wells, and here they are. Domestic wells or livestock wells larger than 10 acres and are incapable of producing more than 25,000 gallons a day. They're exempt. I have worked with districts where the 10-acre requirement is deleted, and wells, domestic wells or livestock wells that produce no more than 25,000 gallons a day are treated as exempt wells. One we see frequently in the Panhandle, I'm sure, all around the state, or oil and gas water supply wells. That's a tricky one and probably is not as great an exception as the oil and gas industry argues. And the well drilled under a permit for mining purposes from the Railroad Commission. Driller's logs. District is required under 36.112 to collect and file driller's logs. A district by rule may regulate by requiring all wells to be spaced certain distance from property lines or adjoining wells, setting production limits based on acreage or tract size, historic use, and adopting different rules if each aquifer, adopting different rules in each aquifer or subdivision thereof, or each geographic area, if the hydrological conditions differ in those areas. Authority to set fees. The district may set reasonable administrative fees based on the cost of the service, such as pump tests and that sort of thing. 36205 authorizes production fees not to exceed $1 per acre per year for agricultural use and not to exceed $10 per acre per year for water use for any other purpose. District cannot prohibit export from the district and cannot impose more restrictive permit conditions on a well that's going to be used for export. However, a district may assess a transport fee under 36122, may impose a fee negotiated between the district and the exporter, or set a rate not to exceed the district's tax rate per $100 valuation per 1,000 gallons of water exported, or 2.5 cents per 1,000 gallons of water export if the ad valorem tax rate is less than 2.5 cents. Levy taxes. The board may levy and taxes to pay maintenance and operating expenses subject, as we talked earlier, to the tax code at a rate not to exceed 50 cents on each $100 of assessed valuation. Tax must be approved by a majority vote of the electors in the district. Adding territory to a district. Individual landowner petition. Territory by petition. The majority of landowners in a defined area can petition a district to be annexed, and if there are more than 50 landowners are sufficient to support the petition. If the annexed property includes an entire county, then the Commissioners Court of that county can petition the district to be annexed. Might mention in the areas, not individual landowner petition, but in the areas by petition for the larger areas, that area has to vote to approve the annexation. Land or territory non-contiguous to the district may only be added if it's in the same GMA. Priority groundwater management area. These are areas that are designated by TSEC of areas that are experiencing or expected to experience severe groundwater issues, and those areas and I've been through this with the district. The TSEC can, as I mentioned earlier, either create a district for that priority groundwater, that PGMA, or that PGMA can be forced into an adjacent district, but only with the district's approval. Legal proceedings and judicial review. Normally, political subdivisions in Texas are immune from lawsuits because of sovereign immunity, unless it is waived by the legislature. 36.066 waives sovereign immunity for districts, and district may sue and be sued. If the district, however, again, prevails in a lawsuit, the court must award it its attorney's fees and costs. Management plan. Let's talk a little bit about the management plan. In my view of what's happened in my experience, the management plan is viewed by the legislature, the state auditor's office, and TSEC as one of the most important duties that a district has in Texas. The management plan, of course, outlines the goals of a district, the steps necessary to achieve those goals, and 36.1071 sets forth in elaborate detail the requirements for the development of management plan. The plan must be reviewed and approved by the Water Development Board. The district must review and readopt its management plan and seek approval of the readopted plan every 5 years by the Water Development Board. If a district fails to submit or fails to receive Water Board approval of its plan, it's subject to appropriate action by TSEC under Section 36.303. I will submit to you, we'll talk about 36.303 in more detail, but that section is TSEC's, one of TSEC's most lethal weapons in its regulatory arsenal, and you'll see why. Joint planning in a GMA, 36.108 details the process for adopting desired future conditions. In setting the DFCs, the GMA district shall consider aquifer uses and conditions within the GMA, water needs included in the state water plan, hydrological conditions of each aquifer within the GMA, and environmental impacts such as spring flow. After the DFCs are adopted by a GMA, an explanatory report must be filed with the Water Development Board, again starting the Water Board approval process. 36.1083 sets forth the appellate procedures for an affected person to file alleging that the GMA failed to establish reasonable DFCs. I think that's a difficult argument, particularly after the Water Development Board has approved the DFC as reasonable. Hearings under Chapter 36. There are 5 general types of hearings. I have really participated in only 4 of these. I'll explain the hearings on application or exceptions to the rules, the district's rules. Hearings involved in contested matters. Rulemaking hearings, we talked about those. Show cause hearings, we talked about those. And this was one that we see very rarely in my districts. Rarely is right, I haven't seen one at all, as a permit application hearing. I know that other districts have these, but particularly in the North Plains district and the Mesquite district that I've worked with, the hearing process is much simpler. But there is a very sophisticated and detailed hearing process for hearings under Section 36.401 and 36.419. Oversight of GCD duties. The State Auditor's Office has oversight authority over districts via periodic inspections. TSEC has oversight authority both on its own initiative and a result of a petition for inquiry. We'll talk more about that. The auditor, state auditor, can audit a district, and the process is for it to determine whether or not the district is operational. Operational is defined as being actively engaged in achieving the objectives of the district's management plan, again emphasizing the importance of a management plan and adhering to it. If the auditor determines that the district is not operational, TSEC must take appropriate action under Section 36.303. It's legislative bad. Petition for inquiry permits an affected person within or associated with a GMA to file a petition for inquiry with the TCEQ. An affected person is very, very broadly defined. It can be another groundwater district. It can be an individual with property groundwater rights within the GMA. It can be a producer of water within the GMA. Very broadly defined. An affected person may file a petition with TSEC requesting an investigation of a district because it failed to. Now, I'm going to only list 2 of these, but in the statute, there are 9 of these complaints that an affected person may allege against a groundwater conservation district. And because the district failed to adopt and submit a management plan to the Texas Water Development Board or enforce substantial compliance with its rules. If TSEC ultimately finds that the petition has merit, TSEC can take a necessary appropriate action under 36.303. And here it is. If there's a violation, TSEC can enforce it under this statute. After notice and hearing, TSEC is authorized to issue an order requiring the violating district to take or refrain from taking certain actions. And normally this, in my experience, has been enforced with a compliance agreement between the district and TSEC. Gets tougher. TSEC can dissolve the district board of directors and call for an election for a new board. TSEC can request the Attorney General to bring the suit for the appointment of a receiver to collect the assets and carry out the business of the district, or the most draconian regulation, dissolve the district. Folks, you've just had Chapter 36 Essentials from 36,000 feet. Thank you.